Do not ignore this warning. The United States Supreme Court has just issued a directive that changes the tactical landscape of the Second Amendment. By a decisive vote of 6-3, the court has signaled the beginning of the end for discretionary gun control. This is not a rumor. This is a verified judicial maneuver. The case is Wolford versus Lopez, and it is the legal vehicle that could permanently dismantle the permit-based carry infrastructure across the United States. While the mainstream media sleeps, a silent war is being fought over your right to carry, and the Supreme Court has just engaged directly. In an unprecedented move, the justices have agreed to review a challenge originating in Hawaii, a case that strikes at the very heart of state power. This is not just about island law, this is about the permission slip society. The core question is whether an American citizen must beg the government for authorization to exercise a right that is already guaranteed by the Constitution. The Supreme Court is no longer willing to wait for the lower courts to clean up their own mess. They are stepping in now. The outcome of this case will reshape firearm laws from the Atlantic to the Pacific. If you carry a weapon for defense, if you value your autonomy, and if you believe the Constitution is a binding contract, you need to understand the gravity of this moment. The permit system is on trial. The Supreme Court almost never intervenes at this specific stage of litigation. Standard operating procedure dictates that the justices wait. They wait for trials to conclude, for appeals to be exhausted, and for a final judgment to be rendered. But in the matter of Wolford versus Lopez, the court has shattered tradition. They granted review early, seizing the case while it is still in the preliminary injunction phase. This is an emergency review. In the world of appellate law, this is the equivalent of a tactical breach. This action signals that the conservative majority perceives a constitutional crisis that is too dangerous to ignore. It suggests that the justices are preparing to not merely uphold the law, but to aggressively reinforce and expand the Bruen precedent established in 2022. By intervening this early, the High Court is sending a broadcast frequency to every lower court in the nation. The time for stalling is over. They will no longer tolerate the systematic undermining of the Second Amendment by rogue circuits. This intervention is the foundation for a new national standard, one that removes the ability of judges to delay justice through procedural warfare. Following the Bruen decision, many hostile states attempted to test the electric fence of the Constitution. Hawaii did not just test it, they tried to cut the power. The state enacted a statute that inverts the entire presumption of legality regarding public carry. Under current Hawaiian law, all publicly accessible private property is designated as a gun-free zone by default. This is the vampire rule. You cannot enter with your tools of defense unless the property owner gives you explicit verbal or written permission. Consider the legal trickery here. Even if you possess a state-issued permit, even if you have passed the background checks and jumped through the bureaucratic hoops, you are considered unauthorized by default. The law presumes criminality. It forces the citizen to prove their innocence at every doorway. This reverses the traditional American view of rights. The practical result is a total ban on lawful carry in public spaces, achieved not by banning guns, but by banning the ground you stand on. A federal district court correctly identified this as unconstitutional, citing Bruen. However, the Ninth Circuit, notorious for its anti-gun bias, reversed that decision and allowed this draconian ban to take effect. That reversal was the trigger. It forced the emergency appeal that has now dragged Hawaii's law into the harsh light of the Supreme Court. In a twist that has stunned political observers, the Department of Justice has effectively betrayed the anti-gun narrative. The DOJ filed a brief that sided, in part, with gun owners. They went on record stating that Hawaii's restrictions exceeded constitutional limits, even by the aggressive standards of the current administration. The DOJ was forced to acknowledge that Hawaii's default ban model violates the core tenets of the Second Amendment. They admitted that public carry cannot be outlawed everywhere by mere assumption. The brief reinforced the critical legal principle that self-defense must remain accessible in the vast majority of public places. This position handed the plaintiffs powerful ammunition and stripped Hawaii of its federal cover. When the federal government, specifically an administration hostile to firearms, declines to defend a state's gun law, it is a catastrophic signal. The DOJ's stance effectively communicated that this law is legally indefensible. They have abandoned Hawaii on the battlefield, making it significantly easier for the Supreme Court to strike decisively. One of the primary catalysts for this Supreme Court intervention is the chaos currently reigning in the lower federal courts. The judiciary is fractured. The Third Circuit and the Ninth Circuit have issued rulings that are in direct contradiction. This is a judicial civil war. The Ninth Circuit upheld Hawaii's sweeping restrictions, effectively nullifying the right to carry. The Third Circuit conversely struck down similar policies as unconstitutional violations of the Second Amendment. This schism creates a constitutional crisis where your rights depend entirely on your geography. The Constitution cannot mean one thing on the East Coast and something entirely different on the West Coast. The Supreme Court cannot ignore such blatant contradictions. By granting review now, the justices are seizing control of the narrative. They are moving to ensure that the Second Amendment has a single, unified interpretation across all 50 states. The era of the two-tiered justice system regarding firearms is being brought to a forced conclusion. When the state of Hawaii realized the magnitude of the threat, they attempted a desperate tactical retreat. They tried to stall the proceedings. They argued that the Supreme Court should not intervene because the case required more evidentiary hearings, more fact-finding, and more time. But that strategy collapsed in real time. Why? Because Hawaii's own attorneys had previously gone on record telling the Ninth Circuit that no further facts were needed. They had admitted that the issue was purely constitutional, a matter of law, not logistics. Their sudden pivot to a delay strategy directly contradicted their own legal filings. The Supreme Court saw through this duplicity immediately. By changing their story midstream, Hawaii undermined its own credibility and signaled that their defense had reached a breaking point. The justices recognized this contradiction not just as a procedural error, but as an admission of weakness. That misstep may have just cost them the entire war. This is the most dangerous mechanism in the modern gun control arsenal. At the epicenter of this case is Hawaii's radical attempt to redefine private property rights to effectively nullify the Second Amendment. Instead of recognizing the right to carry as the default setting of a free society, the state flipped the switch. Under this scheme, it is assumed that carrying a firearm is prohibited everywhere unless the property owner explicitly grants permission. This is a tyrannical inversion of American law. It places the burden on the law-abiding citizen to seek a permission slip for every single building they enter. The district court correctly identified this as unconstitutional, finding absolutely no historical analog in 1791 that justifies such a presumption. The law effectively transforms all public access private property into a patchwork of felony traps. Unless you have express consent, you are a criminal. The Ninth Circuit ignored this, reinstating the ban and forcing this showdown. If the Supreme Court does not kill this property rule now, it will become the blueprint for a backdoor ban nationwide. Every legal argument in this case traces its lineage back to the 2022 decision in New York State Rifle and Pistol Association versus Bruen. That ruling was supposed to be the final word, requiring every restriction to align strictly with the text, history, and tradition of the Second Amendment. But rogue states have ignored it. Now, with Wolford versus Lopez, the Supreme Court is positioning itself to weaponize Bruin once again. The justices appear ready to strip the lower courts of their ability to reinterpret or water down the standard to suit political agendas. The review will focus on how faithfully, or unfaithfully, the lower courts are applying the history and tradition framework. Any law without a strong historical precedent will be presumed unconstitutional. The goal is to incinerate the interest-balancing tests where judges weigh your rights against their fears. The court is preparing to remind the judiciary that the Second Amendment is not a negotiable policy suggestion. It is a command. A primary objective of this review is to discipline a federal judiciary that has gone rogue. Since Bruen, certain circuits have engaged in massive resistance, continuing to use outdated balancing tests to uphold unconstitutional bans. The Ninth Circuit's ruling in favor of Hawaii is the prime example of this judicial insurrection. The Supreme Court's intervention is a direct rebuke. The justices are seizing this opportunity to send a message. The Supreme Court's word is final. The Ninth Circuit upheld a near-total restriction that blatantly conflicts with the Bruen mandate. The Third Circuit issued an opposite ruling, respecting the Constitution. This split cannot stand. By stepping in, the High Court is reasserting its dominance. The opinion that emerges from this case will likely include guardrail language designed to prevent future misinterpretations. Judges will be forced to apply history-based reasoning, stripping them of the power to legislate from the bench. Do not make the mistake of thinking this is an island dispute. The implications of Wolford versus Lopez are continental. If the Supreme Court rules broadly, the entire permit-based carry system could collapse across the United States. A decisive ruling here would establish a single national standard defining the scope of lawful public carry. This is the nightmare scenario for regimes like New York, California, Maryland, and New Jersey. State laws that rely on subjective approval or sensitive place designations to restrict movement may no longer survive judicial scrutiny. Default property bans, the vampire rule, could be declared unconstitutional everywhere. Lawful citizens could gain full, federally protected recognition of their right to carry in public spaces. This case is the turning point. It is not just about where you can carry. It is about whether the government can continue treating self-defense as a conditional privilege. The Supreme Court has locked the target. With the review of Wolford v. Lopez officially granted, the legal machinery is moving at maximum velocity. Written briefs are flooding the docket. Oral arguments are imminent. A decision could land within months. Both sides are mobilizing for total war, knowing that the outcome will rewrite the operating system of American gun rights. The court's review is technically narrow, focusing on the private property question, but a narrow opinion can have broad, devastating effects on gun control if it reinforces constitutional limits. States are scrambling to rewrite their laws before the hammer drops. Gun rights organizations are fortifying the plaintiffs with amicus briefs. This is the most significant firearm case since Bruen, and the decision will set the tone for the next generation of litigation. Whether the court strikes broadly or narrowly, the result will define the geographic limits of your freedom. The next battle has begun. The Supreme Court's decision to hear this case marks the opening of a new front in the war for constitutional rights. Wolford v. Lopez is more than a dispute over Hawaii's statutes. It is a test of whether the government can continue to force citizens to beg for permission to exercise a right that is their birthright. Watch every filing. Watch every argument. This is where constitutional theory meets the street. The outcome will determine if your right to self-defense ends at your front door. Subscribe, share, and stay informed. The next ruling could reshape the Second Amendment forever. Stay vigilant, stay prepared, and most importantly, stay free.